Hi, it's Jessica from Leverage Legal Group. So let's say that you discover that somebody has copied maybe your website, your course materials, maybe your photos, your work, and you're angry, you're frustrated, and your first instinct is to call a lawyer and sue. But then you discover, or maybe remember, that you never registered a copyright in that work. So what now? Can you do anything about it? Can you stop them? Can you get damages? So let's walk through exactly what your options are, what you can do and can't, and what to do next to protect yourself for the future. So here's the good news. You still own a copyright in your work, even if it's not registered. In the United States, copyright protection exists automatically the moment your work is fixed in a tangible medium. That means as soon as it's written, recorded, saved, filmed, or published online. Ownership is automatic upon creation. Even though that's true, you have the right to control who uses your work and to demand that infringers stop. And you can send a cease and desist letter or a DMCA, Digital Millennium Copyright Act takedown notice to have the content removed from websites like YouTube, social media, etc. Those tools are effective without registration. But when it comes to filing a lawsuit or collecting money, that's where things change. And I would hesitate to send a cease and desist until you address this issue, because sending empty threats to somebody that you can't back up with a lawsuit is a really risky move strategically. So the reality is that you cannot sue for an injunction to stop them, and you cannot sue for damages until you get your copyright registered. Under the copyright statute in the United States, you must do that. And not only do you file for registration, but the Copyright Office has to approve it and send you proof that you're registered. It can't just be the submission of your application. And the Supreme Court made this clear in a case called the Fourth Estate in 2019. So if your work isn't registered yet, you need to register it before you can sue. And once it's registered, then you can move forward legally. But your potential remedies will be limited because of when you registered it. So first of all, before you start sending cease and desist letters, the first thing you need to do is go get your copyright registered before anything else. If your work wasn't registered before the infringement began, then you lose access to the most powerful tools that are available to you under the Copyright Act. And those are statutory damages and attorney's fees and costs. Late registration means you don't have access to those things. So that means you cannot claim the automatic amounts that are sort of set forth in the copyright statute, which are called statutory damages. And the range for those is between $750 to $30,000 per work. What's nice about statutory damages is that you don't have to prove that you've been damaged financially. If you can prove that there was infringement, meaning unauthorized use of your copyrighted materials, and you can prove that you have registration, then you're going to automatically get something in that range. And generally, it depends on the amount of what was copied and the egregiousness of the copying. But you're going to get automatically something if you prevail. You don't have to prove financial harm. But if you didn't register, and generally you need to register within 3 months of your first publication of that work, publication meaning just sharing it with the world. If you didn't register it within that first 3 months, and you definitely waited until after the infringement, you're not going to be able to claim those automatic statutory damages. And you're also not going to be able to ask for up to $150,000 per work for what is called willful infringement, which is available to you if you do register it in a timely way. If you register your copyrights in a timely way, you also have the option or possibility that a court may award you attorney's fees and court costs for having had to pursue your rights. None of those things are available to you if you wait to register your copyright. So make sure you are getting registered copyrights in anything that you want to be able to protect and not have other people copy, so that you have those remedies available to you. Now, if you waited and you're in the situation where you have unregistered copyright and you've been infringed upon, you go get your copyright registration in that item. What you do have is the option to prove actual damages or profits that the infringing party made off of your original work. So you're either going to have to prove that you lost money, or you will prove that the other side made profits off of your work. And those are things that you can recover. But obviously, it's going to take more time and money to be able to prove those. So it's just a little bit harder to do that, but not impossible. How do you prove that you've been damaged? Well, it could include lost licensing revenue that you would have had otherwise, lost sales, or, and the income from those sales, lost opportunities even. And then obviously, as I mentioned, the infringer's profits that came directly from your work. Once you register the work, you can still file a lawsuit for an injunction, which is a court order requiring the infringer to stop using your work. You can ask the court to impound or destroy the infringing materials, and you can use the Digital Millennium Copyright Act to get infringing content removed quickly online. You can still stop the infringement, which is great news, even if the financial recovery is limited. But remember, you can't do that unless you have a registered copyright. So how do you avoid this in the future? This is how I help my clients avoid this situation entirely. Number one, register proactively. Register your website, your course materials, your videos, your photos, anything that you have created that's your original work and that is core to your brand or to your revenue streams. Do that as soon as it's finalized. That way, you have that protection. And you can register multiple works as a collection sometimes to save you time and money. To determine whether you can do that, though, I highly recommend that you consult with an experienced copyright attorney to help you determine how to register and if there's a collection, if it's something that's going to qualify as a collection under the Copyright Act. Number two, keep really good records. Save drafts of your creations, emails, and upload confirmations to prove your creation timeline. You have to be able to prove that it was your original idea and that you were the one that created it. And one of the best ways to do that is saving the iterations and the different drafts from the time you started working on it. Number three, include ownership clauses. So make sure that when you're working with contractors and freelancers, that they sign what's called a work for hire agreement. And that basically is giving an automatic grant of the copyright and whatever they're creating for you to you so that your business owns everything that it pays for. And let me just explain why this is an issue, because under the Copyright Act in the United States, if you're working with contractors, freelancers, outside vendors, and service providers, and they're not W-2 employees of your business, then they actually own the copyright in anything they create on your behalf, even though you're paying them to create it for you. So you have to have a contract that explicitly grants the rights of those works and the copyright in those works to your business so that your business owns them. If you don't have that language in place with these contractors and freelancers and vendors, then you don't actually own the copyright in any of these items and you cannot get a registered copyright in them. So if you're in that situation, the first thing you have to do is go back to these freelancers, vendors, contractors, and get them to sign a work for hire agreement or a copyright assignment agreement. You need an experienced copyright lawyer to assist you with this, to make sure that these are done effectively and that the agreement you have in place is enforceable. Once you have that, then you own all of your works and you can get registered copyrights in them. Please make sure you do this in the future because the cost of registering your copyrights is pretty small compared to the cost of defending your rights without it. So if someone copied your work, or if you realize that your key content isn't registered, let's fix that. I can help you figure out your current risks. I can help you file the right registrations and create a plan to protect your content going forward. Just give me a call and we'll figure out a plan together. You've worked hard to build it, so let's make sure it's legally yours and that no one can take it.